Welcome. Good morning and welcome. My name is Paul Blaustein. I'm the chair of Regional Family Support Planning Council number 5. I also serve as chairperson of the New Jersey Council on Developmental Disabilities. NJCDD is mandated and funded by the federal government, and there is a council in each of the 50 states and the District of Columbia, as well as the 5 U.S. territories, for 56 councils overall. Our members are nominated by the governor and are confirmed by the state senate. NJCDD serves people with developmental disabilities. We inform and we represent you. We welcome your participation in our activities. You can reach us on the web on njcdd.org, njcdd.org. The regional councils, and there are 10 of them in the state of New Jersey, covering all 21 counties, are funded and supported by NJCDD. They are also basically mandated and regulated by state law. Regional Council 5 is one of the 10, clearly. We cover the 3-county territory of Middlesex, Mercer, and Hunterdon. We generally meet on the second Tuesday of each month. We do not meet in the summer months of July and August, and we do not meet in December. And sometimes, as in the month of May, when we have a statewide meeting of all 10 councils, which this time comes on the second Saturday in May, we will meet on the 4th Saturday in May. Again, you can get in touch with us through the link that you can find on njcdd.org. We invite you to attend our monthly meetings, which now and for the foreseeable future are virtual. So it's easy for people to participate. I just want to briefly address the subject of today's family forum, which is succession planning. I can think of no more important task or responsibility for the parents of an individual with developmental disabilities than succession planning. Know that you have devoted your life to taking care of your children, but just as an example, my son Jonathan is 29 years younger than I am, and I'm aware every day that I expect him to live, I don't know, let's just approximate at least 3 decades beyond my ability and my wife's ability to take care of him. So it's absolutely essential that we arrange for succession planning. We prepare him for life without us, and we prepare successor documents, successor people to be there to either help Jonathan or in some cases take action or make decisions for him. This is the most, as I said, this may very well be the most important decision you make. I often tell people, including when I testify before the state legislature, and I've said this to the first lady, of the state of New Jersey, Mrs. Tammy Murphy, that the essential difference between parents who have a child with developmental disabilities and other parents is that if you don't have a child with developmental disabilities, the worst thing in life that you can anticipate or hope never happens is that a child of yours will lose their life or die during your lifetime. For myself, my wife, and the rest of us, the worst thing that we can imagine is that we will pass away or become incapacitated during the life of our child, leaving our child alone, potentially, and defenseless. So it's absolutely essential that we prepare our child and successor caregivers for that eventuality. I'd like to, introduce our guest speaker, Ellen Nalven, who is the executive director of Planned Lifetime Assistance Network of New Jersey, abbreviated as Plan New Jersey. When we decided that we were going to do this, it was very, very easy to determine who we wanted to invite to be the speaker. As I told Ellen earlier, my plan B was if she wasn't available, I was going to plead with her and grovel and just ask her when she would be available, because I don't know anyone who has the knowledge, experience, and dedication to this subject than Ellen has. Just a brief comments on her background. She educates families on the importance of life planning to promote independent living and quality of life for individuals with disabilities. In this role, she serves as legal guardian and trustee of special needs trusts and oversees the delivery of case management, advocacy, and life planning services for nearly 1,000 individuals. Previously, she served on the faculty of the Department of Psychiatric Rehabilitation at the University of Medicine and Dentistry of New Jersey. She participates in several national organizations, including as a member of the board of directors of the National Plan Alliance, and has been recognized numerous times for her accomplishments and knowledge of this subject. So I'm going to allow Ellen to give you her presentation, which I hope will include some details on how Plan New Jersey can help you, because I know that this is going to sound like a very daunting experience. And my fear is that if it sounds too difficult, too many people will be reluctant to embark on succession planning. But there are organizations like Plan New Jersey who can help you and assist you both in devising your plan as well as helping to implement the plan during your lifetime and also after, when you are no longer available. They can help ensure that your child is protected and has a safe, healthy, happy, and fulfilling life. So without further ado, let me turn it over to Ellen Nalven and thank her for giving us her time and knowledge.
Thank you so much, Paul. I appreciate that introduction, and welcome everyone. This is certainly a very challenging topic, and I really applaud all of you for being here to think about it, learn about it, and as Paul has talked about, probably the most important thing you can do in terms of succession planning, I'm going to refer to it as life planning, is really to get started, is just to get started, to start addressing the questions. We have some tools on our website. I'm going to share some of them with you today on our in the PowerPoint. And just remember that unanswered questions can be answered in the future. We never have all the answers to all the questions we have. The best advice that I can give is to just try and, start to write down those things that are important to you, important to your loved one. So I am going to share my screen so I can put up a PowerPoint presentation. And this is the agenda that we're going to speak about today. Succession planning can be thought of in a number of different specific categories. And what we're going to do today is we're going to talk about legal planning, financial planning, and home and community planning. We're going to address these specific areas, ways that you can think about future people, roles, and tasks that need to be taken care of. And what we're going to do is we're going to start by talking about home and community planning, and then we're going to move into legal planning, financial planning, and then come back to home and community planning. I think by sandwiching in the more technical aspects of things, I might be able to keep you awake this morning. We'll talk about guardianship and surrogate decision-making. We'll talk about, in terms of financial protections for people with intellectual and developmental disabilities, we're going to touch on special needs trusts and ABLE accounts. And this whole, the entire presentation is for the purpose of securing a good life, a quality of life for your loved one, or maintaining that life that he or she has now. So I do want to tell you a little bit about Plan New Jersey, because we are here to assist with any of this aspect, any or all of this, in any way that we can help you. So we are a statewide not-for-profit organization, and we are in our 34th year of service to families of people with disabilities. We do serve people with all different kinds of disabilities, intellectual and developmental disabilities, mental illness, physical disabilities, And we are a member of a national organization called the National Plan Alliance that helps us really stay current, because much of what we do is nationally, federally organized, like special needs trusts and, federally legislated. So staying on top of the rules and regulations and changes to those ABLE accounts and other things is really critical to delivering the services in a quality way. So our mission is to help families answer the question, who will care for my loved one when I'm gone? So that's really what we're talking about when we talk about succession planning is, what do you do now? And what do others do now? And how do we maintain that? And who's going to do it if you can no longer continue in that role? So the things that Plan New Jersey does is we serve as special needs trust administrators. We are trustees of both private special needs trusts or individual trusts that your own attorney might have written for you, but we also have what's called a pooled special needs trust. So I will talk with you later a little bit about this, but the pooled special needs trust is a way for families who may not have a lot of resources, or maybe there is going to be a small amount of money in the trust. You can sign up for that trust. There is no cost for signing up. It can just be there waiting for you. Because some families say, well, I don't know that I'll have any money to put into a special needs trust. So one of the topics we will talk about later is the fact that all you need is anything over $2,000, if you recall, with the limits for eligibility for Medicaid and SSI. So Plan New Jersey serves as trustee for special needs trusts. We do quite a bit of advocacy and case management services that we refer to as home visit monitoring. So this service can be very helpful for future guardians, future caregivers, your successors, because they may be out of state. They may be very busy people. They may be professionals. They may have children of their own. And so very often families, one of the things they do in planning is to say, Plan New Jersey, I want you to be there for my successor. So they can call you if they have a question, a problem, they get a scary letter, we're there to assist and guide your successors. And then we do serve as legal guardian. We are guardian for 40 people. And this is very often, sometimes we're appointed by the court, but other times this is for families who are guardians themselves for their children, and they have nobody else. There is no family to serve. And then they want a very individualized, personalized guardian service. And so we do that for 40 people. Life planning is the topic of our session today. And one of the things we talked about, Paul had an interesting insight. He commented that perhaps one of the reasons families hesitate to do life planning is because of, first of all, it's extremely emotional. It can be very, very difficult to think about your own demise. And I've heard that from many families, but he also commented that, maybe it's a fear of failure. I don't know if I'm going to be able to do this. I don't know if I have anybody to be successor, so I'm just not even going to think about it. So that was an interesting insight, I thought, on Paul's perspective. And then representative payee. It's another important service that Plan New Jersey offers for families who may need an alternate going forward. And so we can serve in that successor capacity. So let's get started on talking about life planning and what that entails. So first of all, a comprehensive life plan has three basic components. One is, and the majority of this is about who is your loved one? Who is this person? What is their story? what are their needs, but also what are their wishes, their hopes, their dreams, their preferences, and their goals. So think of a life plan as the person's story, their memories, their history. History can be so important because remember, if someone goes through a trauma, they may not, look like the person that they were 6 months or a year ago prior to the trauma. And so having a life plan that really describes who they are, what they do, what they like, what makes them happy, what makes them sad. How do you help with those things? That's a critical aspect of a life plan. And then, of course, resources that they either have or that they need, you want them to have in the future. And then of course, the third aspect is who are the people. So identifying your successors, who's going to implement this plan or who does it now, the nature of the public services that you have or the community services that are in place or neighbors that help. So we want to talk about the person, the resources, and the people to implement the plan. So the people to implement the plan, we want to break this out into components. So we want to think about legal roles, who will cover perhaps being successor guardian or successor supported decision maker. If the person has appointed you or another family member as power of attorney, they don't have a guardian, and healthcare proxy, that can be a very effective legal protection, but who will take their place in the future? Financial roles, this might include trustee, representative payee, able account manager. We'll talk a little bit about that. And then home and community supports. We know that these are critical to many people and they must be individualized. So we want to know who in what capacity do people assist very specifically on a day-to-day basis, month-to-month basis, who helps with daily care if needed. How do you describe their quality of life? What are their medical needs and who assists the individual? They may be perfectly capable of managing their own medicine, but maybe not at all. Maybe they need somebody to handle that. And who do they like? What are their relationships? And that is critical to be included in a plan, because if somebody steps in that doesn't know you or your family or your loved one, they might not know of that cousin who loves them and wants to be a part of their life. So we want to be talking about the relationships as well as listing contact information. So what we're going to do is move on to the legal section, and then then we'll talk about guardianship, financial supports, and then go back to this concept of life planning for personal supports. Legal guardianship. Some families feel that there is no question that the person needs a legal guardian and they need the protection and they need someone to advocate on their behalf. This mother with her son has tremendous medical needs. She is his guardian. He does not speak and really needs help with all aspects of care. So there is no question that she knew she needed to become his guardian. And at age 18, she did. And so she is responsible, appointed by the court to care for his medical needs, his housing needs, his legal, financial. She is responsible for all aspects of his care, and she applied at age 18 to do this and was appointed by the court. Some families are very concerned about guardianship because they don't want to take away the rights of their loved one. And they know that the loved one has capacity to make certain decisions or all decisions, but just needs help and support. We all are interdependent. We all have friends or family or spouses that we go to for help. But sometimes people need a much more intensive level of help. And in this case, they need to go to the court to be appointed guardian, and the pleadings go to the court for this purpose. I'm going to be talking today, telling you the story of a woman named Barbara and her sister Mary, and to sort of illustrate some of the points that I want to make. And I have full permission to talk about Barbara and her sister. One of the things that Barbara told me about her sister and was that many years ago, upon Mary's parents were her guardian. Mary had Down syndrome. Mary sadly has passed away. But for years and years, Barbara was a marvelous and wonderful guardian for her sister Mary. And so one of the things Barbara was a bit surprised about was the fact that on Barbara's 18th birthday, her parents said, "Happy birthday, you are now Mary's guardian." So they had gone to the court and had Barbara appointed co-guardian. And then they sadly passed away, both of them within about 14 months of one another. And then Barbara was sole guardian for Mary. And so Barbara needed to investigate, what are her responsibilities? What does she need to do as guardian? And one of the critical responsibilities of a guardian is to visit the loved one and know what they're doing, know how they're doing. The National Guardianship Association standards recommend a minimum of 12 visits a year, once a month. And Mary definitely did that. Actually, Barbara visited Mary a number of times, and because Mary had been living with her parents, and when the parents passed away, Barbara felt that Mary could really do well in a supervised apartment, and so she did go through DDD and secure a placement in a licensed supervised apartment with an agency, one of the county ARCs, and that was an excellent, wonderful experience for Mary. Mary just enjoyed her life in this supervised apartment. And one of the challenges that Barbara found was balancing Mary's autonomy and her independence, but also protecting her from harm. And that is her job as guardian, is to promote her self-determination, promote her ability to make decisions for herself, support her own decision-making, while at the same time making sure she's safe and healthy and well. So another responsibility of the guardian, and by the way, this is written in the law, the New Jersey guardianship legislation, is that a guardian is required to promote self-determination. So it's not just a nice thing to do, but it's an essential thing to do. So guardians do not have the right to just simply decide what's good for the person and do that. In fact, if an individual, a guardian, the term is ward, I don't love that term, but if a ward, a person under guardianship feels strongly about the fact that they should not have a guardian, it is the guardian's responsibility to bring that case to the court or to evaluate and assess that question, whether or not they should have the guardianship removed or revoked, and take it to the court to make that determination. The other thing that's important, that is a responsibility, is to do annual reports to the court. And this is a form. It looks a little intimidating when you first look at it. It's available online, but in fact, one of the things that we did for Barb, and we do for many siblings, is help them with that report, meaning guide them through what the court is looking for, what they're asking for, and assist. So sometimes if a sibling becomes a successor, it can be very helpful to have assistance to know about these things that are very critical, Some courts don't even read these reports. There is a volunteer group that is supposed to read them, and many cases do. We have some counties who contact us to ask questions about the report. We have other counties where we don't know whether they're reading them, but we submit them for all 40 people that we are guardian for, of course. And we have other situations where family members have come to us because they got a letter from a particular court that said, we haven't received your report, and if you don't give it to us, we are going to remove you as guardian and replace you with somebody else. So it can be a very serious thing. And sometimes families say to us, but wait a minute, I'm his parent. Why should I have to do this? Well, this is a legal role. So, and don't forget, feel free to put your questions in the Q&A box. And later on in the program, Paul will help us with answering those questions. But we're going to see whether we're going to move forward and with our various topics. But write them down so you don't forget them, and we'll come back to them. So I mentioned self-determination, which is just a critical aspect of our field. We do not want to take away rights and responsibilities from individuals if we can possibly help it. And in some cases, in some states, there is a concept called supported decision-making that's actually in law. So in some states, Florida is one of them. There are a couple of other states, I think maybe 12 states, have supported decision-making legislation where the individual can have a supported decision maker appointed by the court, which just gives that decision maker more teeth. So there are a number of us in New Jersey that are very interested in pursuing supported decision-making in New Jersey so that we can have another alternative to guardianship, because we only do want to take away rights if necessary. Now, there are other, I do want to mention before I talk about other alternatives that there is something called limited guardianship, and many judges are looking to really look to promote limited guardianship and to appoint only a limited guardian. So they're always looking for the functional abilities of people who have been presented to the court for a potential incapacity hearing. The judge will look for helping them, allowing them to retain their rights whenever possible. So the powers of attorney in healthcare proxy are an excellent tool. Every one of us, all people who are over 18 should appoint a power of attorney and healthcare proxy, because things happen and we could become incapacitated, and for, even just a brief period of time. And a power of attorney then has the right to do banking on your behalf and make healthcare decisions on your behalf. So there is absolutely no reason why a person with disabilities can't have a power of attorney and healthcare proxy. And perhaps that's all they need. They don't need a legal guardian. The cautions here are that it is revocable. It can be, the individual could just tear it up. So if your loved one, if your son or daughter is very cooperative and asks for your help, and same, and with your successors, it might be a great tool. But then if they get angry with you and they tear it up, then you have no legal protection. So that's something to think about. I do recommend, if you're thinking about a power of attorney for a person with a significant disability, that you definitely go to an attorney, and not just any attorney. Go to an elder law attorney or an attorney who has expertise with people with disabilities. I list about 40 of them on our website, people that we know and trust and know that they are very skilled in working with people with disabilities. And we want to do that because the attorney who is experienced and knowledgeable about people with disabilities is going to is going to be making a legal judgment as to whether or not this person does really have the capacity to sign a power of attorney and healthcare proxy. And we want that because you wouldn't want a doctor to look at a power of attorney and say, oh, this, you downloaded this from the internet, and I don't believe they had the capacity to appoint you in the first place. So we want to make sure that it is a document that that doctors and banks will honor. Representative payee for Social Security benefits, of course, is a way of protecting people, so that if they are vulnerable to exploitation or making sure, or even eviction, we have been appointed by the court several times because somebody has been threatened with eviction, and it really was just that they couldn't manage their budget and didn't pay their rent on time. And so knowing, a judge would cancel the eviction application if just because they had been appointed, the person had been appointed a representative payee. This has to be done by the Social Security Administration, though, not by the courts. So, a trustee is a legal protection, a trustee of a special needs trust. It may be that it's financial issues that people need support and assistance with. And for other decisions, healthcare decisions, housing decisions, they can manage these things well on their own. And a conservator is sort of a nice balance between the two. A conservator is somebody that can manage, typically it's financial matters, but it is a court appointment, and it's voluntary. So the person with a disability has to say, yes, judge, I want this person to act as my conservator and to manage my financial affairs. And then it's blessed by the court, so a bank must honor it. So that's the difference, is a guardianship is blessed by the court and appointed by the court, as is a conservator. And that's very helpful then, because, the bank can't say, no, I'm not going to honor this. It's a court appointment. So we talked about legal protections. I'd like to talk about financial protections a little bit. We talked about representative payee for Social Security benefits. You should know that a relatively new law enables the individual to select who they want as rep payee, and that must be honored by Social Security unless otherwise, unless there's a reason that they feel that person should not serve in that capacity. We will talk about special needs trusts, and we'll talk about able accounts as other. So these are three kind of common financial protections. And again, if you have these three, even potentially all three, you may not need a guardian of the estate or property. Guardianship can be just personal, guardian of the person for medical and housing needs, or it can be guardian of the estate for legal and financial needs, or it can be both. So you may not need it if you have these protections. So first of all, why do we need these protections beyond vulnerability, potential for exploitation? Can't tell you how many people, that we serve, they've lost a lot of money. They've gotten into debt just because they're vulnerable. And, you can walk into, many department stores, walk into TJ Maxx, guaranteed they're going to be asking you to take out a credit card, and they're going to, we've had people who are under guardianship who've been successful at getting credit cards. And the benefit though, is because they were under guardianship and they charged up whatever, $1,000 in or more in purchases, we were able to say, sorry, we're the legal guardian, and you're going to have to eat this. So the guardianship does protect people. We can refuse to pay and absolutely legally able to do that because the guardianship doesn't disallow somebody from signing contracts, which include credit card applications. So, but why is it so important? Because many people with developmental disabilities require the supports and services of the Division of Developmental Disabilities. And Medicaid is required. Medicaid is also required for most services under the Division of Mental Health and Addiction Services, and many other services. Medicaid is an eligibility criteria. So, and as you probably know, supplemental security, if one is eligible for SSI, then you automatically get the federal Medicaid program with that in New Jersey. Other criteria that are means to other services, benefits that are means tested, housing vouchers, SNAP benefits. We really need to maintain these benefits or even maintain protection for eligibility. And the special needs trusts and ABLE accounts are two tools that allow you to do that. And it's so critical because of these supports and services that are funded by DDD I'm getting an internet is unstable message. I hope I stay with you. We'll just giving you a heads up. Hopefully everything will be, will stay stable. Supports and services are expensive. So you really have to have millions of dollars to provide the supports and services if somebody needs housing and supports in home. Medical care is, we all know. So how do we protect these things? Special needs trusts are a critical way of protecting federal public benefits, whether they're managed federally or statewide. Medicaid is a critical one. SSI is a critical one. All of those that we talked about. So a special needs trust is like an empty cup. It's a document, looks like a will. It's a legal document that has very specific language. So what it does is the language in the trust says that the beneficiary does not have access to the trust. And what that means is that any resources, any money that's in the trust, any assets are not something that the individual has control over. Therefore, the money in the trust is considered an exempt resource. Medicaid has to know about it. They have every right to ask for the trust, ask for the bank statements. You could have $10,000 in it. You could have 100,000. You could have 1 million. It is an exempt resource as long as it's properly written. So the person can have all of those means tested benefits, but still have assets, whatever amount, that allow for, improved quality of life. We know that living on SSI for food, clothing, and shelter at about $800 a month or so doesn't make for a good quality of life. Try to find rent. It's impossible. There's no rent in New Jersey that is, that $800 covers no less food, clothing, shelter, food, clothing, and other needs, haircuts, shampoo. We have a lot of needs in our lives. So special needs trusts can hold assets, money that can be used to purchase those things, to supplement all of these resources, to the things that the means tested benefits provide. So there are many things that a trust can purchase: transportation, personal care assistance, education, recreation, clothing, electronics, furniture, many other things. So let's go back to Barb and Mary. When Barb was appointed guardian for Mary, her parents did tell her, they had a conversation and they told her that they had gone to an expert elder law attorney and that attorney had written a trust for Mary, a special needs trust. So there was no money in that trust. That's kind of typical, that it's kind of like an empty cup. It's a legal document. And when her parents passed away, when the second parent passed away, then a portion of the family's resources went into the special needs trust for Mary's benefit, and Barb was appointed trustee. Now, where was Barb appointed trustee? in the parent's will and in the trust document itself. That was part of the way the legal process happened to make sure that Barb would serve as trustee of this trust. Barb then said, uh-oh, I better do some succession planning myself. And as Paul talked about the critical nature of this, and so she came to Plan New Jersey. We wrote a life plan which described all about Mary, about her supervised apartment that was the ARC, where it was operated, where she was living, what she was doing, what she liked. And I'll talk to you more about that, but it also described the special needs trust, and it indicated that Plan New Jersey would be the successor trustee once Barb could no longer serve. And Barb went back, changed her will to have that indicated that Plan New Jersey would serve as successor trustee, and also, by the way, successor guardian, because Barb has one daughter, did not want to require her daughter to be Mary's guardian, and so she also appointed Plan New Jersey as successor guardian, should she not be able to serve in the future. So what did Barb use the special needs trust for Mary? She took her on trips and was able to pay Mary's way, airfare, hotel, and entrance to amusement parks and that kind of thing, and music and movies and that kind of thing. She bought her an iPhone and an iPad so that she could Mary loved to play games on the iPad, so she paid for those. She bought her furniture when she moved her into the supervised apartment. She bought her some, and again, my internet is unstable. I do hope we connect here, we stay connected. So the other thing that Barb did was she paid for a companion. So we talked about a guardian's responsibility to visit the individual under guardianship. And Barb visited a lot, virtually every weekend and often during the week as well. But she wanted to make sure, especially when Mary moved into her new supervised apartment, that Mary had lots of attention and lots of company, in addition to the direct support professionals that were helping her. And so she hired a companion who visited every weekend and took her out on outings, took her out. She loved ice cream, so took her out for ice cream and took her for walks and tried to get her the fresh air that she enjoyed and motivate her to walk, because she wasn't thrilled about walking. So she used the Special Needs Trust in a number of ways to enhance and enrich Mary's life. So I'll just briefly talk about two types of special needs trusts. There is a third-party trust and a first-party trust. So again, remember, I have families who say to us, a trust, that's for rich people. No, not necessarily. That's for people who might leave more than $2,000 to the loved one through an inheritance, or a parent, grandparent might leave some resources. And so it should be left to a special needs trust rather than directly to the person. So in Barb's case, her parents, once they passed away, they had a life insurance policy that was to fund the trust, and also they had some assets. So they, had a couple of IRAs, and the portion that they left to Mary went into their third-party trust. So that legal document that had certain language in it that was like an empty cup, now that got filled. Barb opened a bank account that was in the name of the trust using Mary's. She got a separate EIN number, so that it was certainly not Mary's. It wasn't Barb's or Mary's assets. It was a separate number, so the IRS couldn't consider it Mary's assets. It was Mary's parents' assets left for her benefit. That's called a third-party trust. Now, that life insurance policy, fortunately, they named the beneficiary of the life insurance policy to be the third-party trust. Again, your lawyer helps you with this. I'm not a lawyer, I'm not giving you legal advice, but I'm sort of talking from my experience that if, and many families make this little mistake, oops, I forgot to change the beneficiary of an IRA or from a life insurance policy. I forgot to change it to the trust. I left it directly to the individual. Well, it's not the end of the world, but this money then can go into a first party or self-settled special needs trust because it belonged to the beneficiary, it belonged to Mary. If they had made a mistake and done this, the money would have been Mary's, or if they had not had a will and they just left it to Mary, half to Mary, half to Barbara, then the money would have had to go into a first party trust, which is fine, but it has more restrictions. Medicaid watches carefully over first party trusts because they are keeping an accounting, and at the end of the person's life, anything that's left does have to be paid back to Medicaid because Medicaid is paying lots of dollars, hundreds of thousands, if not millions of dollars to cover the services and supports for individuals with disabilities. So I do want to dispel a myth, though, that not every special needs trust is payable back to Medicaid, only the ones where the money directly belonged to the beneficiary. Either, maybe they were a victim of a car accident and there was a settlement, and that money definitely goes into a first party trust because we want them to maintain their Medicaid and not have to spend all that money down and then lose the Medicaid and then go back on Medicaid. So let me talk briefly about ABLE accounts, and then we're going to go back to special needs trusts a little, rather to life planning for home and community supports briefly. So an ABLE account is another tool established in 2014. It's called the Achieving a Better Life Experience Act. So one of the challenges with a special needs trust is, by law and by nature, the individual does not have control over those assets. They can't say, they could try to ask for, we have people who ask us, buy me a Lexus. I need a new car, buy me a Lexus. And we as trustee have to say, your parents wanted this money to last your lifetime. So unfortunately, we got to go with a Honda or a Ford. We can't buy a Lexus. Or another person was a guitar collector and he wanted us to buy him guitar after guitar after guitar at a tune of, he was talking $3,000 or $4,000 per guitar. And again, we had to say, well, how about we buy you one guitar a year on your birthday? And, so sometimes it's helping a person to understand the purpose of all of the funds, the various intent of the family, and families want to do budgets to do this. So an ABLE account gives a person more control over their own assets. So if a person establishes an ABLE account, the individual themselves can, a guardian can, certain people can open ABLE accounts on behalf of the individual. Generally, the person does it themselves. And it is similar to a special needs trust because it does protect those means tested benefits. Those assets, any amount that's in there, are considered exempt from as far as SSI is concerned and Medicaid is concerned. So the advantage is that it gives individuals more choice and control over spending. So if you've got somebody, so I mentioned people's vulnerabilities, and sometimes people will get taken advantage of. People know they have money or, you know, and people say, hey, give me some of that. So we can help to teach people how to protect themselves and manage their own money. Maybe they, you know, just kind of, as soon as they have money, they spend it willy-nilly. We can teach people how to budget, how to manage their finances by giving them an ABLE account, and they might get a debit card from the ABLE account. But we do have to know that that person can spend every penny that's in there. They do have full access, but it's also a benefit because they can have more choice and control. So it is another way to protect SSI and Medicaid, which is an important tool. This is a bank account. Not, you don't just go to any bank to open a bank account. Most banks won't be able to tell you anything about it. You have to go to a state ABLE program. And so I think on the next slide, I have a link to this. Let's see. No, I don't, but it's called Save with ABLE, savewithable.com. And you can go //New Jersey. But you can also join the Ohio program or the Florida program or the Pennsylvania program. And sometimes there's reasons to do that, to use a different state's ABLE account. But the basic of this, and the Save with ABLE helps you compare why you might go to a different state rather than New Jersey. So you can have, you can put, and this slide is old, the contribution limit is now $16,000 for 2022. So that means you can put in as much as $16,000. So let's say there is an inheritance. It may make a lot of sense. And let's say the inheritance is $14,000. It might make sense, or even up to $16,000. It might make sense to open an ABLE account and put the money in there. And sometimes with these amounts of money, lawyers, attorneys will recommend spend it down, open a prepaid funeral trust with the choices account through a funeral home. Those two are exempt from Medicaid and SSI. So the amount can grow to $100,000. Medicaid still, even if you go to 101, your SSI will be cut off until you go back down to 100, but Medicaid will remain intact. So this is very important. Two other important points about ABLE accounts is that the person has to have become disabled prior to the age of 26. So for people with intellectual and developmental disabilities, this usually works well. For people with mental illness or physical disabilities that we might not be able to document that illness prior to age 22, they may not be able to access this. And you should know that a person can have only one ABLE account. Accounts are not taxed as long as it stays below $100,000. And the expenses that we talked about for trusts are very similar to the expenses that can be made out of an ABLE account. They're called qualified disability related expenses, QDE. So they can be furniture, tuition, gas, certainly medical equipment, medical, lots of ways to pay, and rent and food can be purchased out of an ABLE account. So one of the common questions is, can I pay rent out of a special needs trust? And the answer is yes, you can. However, there will be, if rent is paid out of a special needs trust, the SSI amount will be reduced. So one of the things we do for several people at Plan New Jersey is we will pay their rent into an ABLE account. And as long as that rent is paid the same month that it went in, pay it, and we'll pay into the ABLE account $1,500 for rent or whatever it is. And as long as that money comes out in the same month, $1,500 for rent, the SSI does not get reduced. And so that's a very nice new method of managing finances. And then the other thing to know is that we talked about third-party trust and first-party trusts. A third-party trust is not payable back to Medicaid a first-party trust is payable back to Medicaid, meaning at the end of a person's life, and so is an ABLE account. That's my point here. So what happens is at a person's passing, you the ABLE account owner or the trustee of the special needs trust must notify Medicaid that the person has passed away, and Medicaid keeps an accounting of what they've spent. The family or trustee has the ability to review it to make sure it's accurate, but then it needs to be paid back, whatever. So if they've paid, $200,000 in bills for DDD work or medical coverage, and you have $100,000 left in ABLE, all of it's going back to Medicaid. So we talked about legal roles, we talked about financial roles and financial planning. I'd like to go back to home and community-based supports for a minute. So what are we talking about here? Probably the biggest thing that we want to plan for is housing. We also have to plan for medical needs, emergency response, relationships, who's friends, who's family, what are person's hobbies, what recreation, and what people are in people's lives, as we talked about. So how do we do that? How do we remember all that stuff, plan for all that stuff? So there are a couple of things that I took from a book that I really enjoyed called People Planning Ahead. And one exercise is called Planning Ahead, Favorite Things, End of Life Decisions. So this is probably one of the hardest things that we have to do, a guardian has to do, is make end of life decisions. And so what we want critically to be sure that we're doing is, first of all, reflecting. And this is where your succession planning is so critical, because you want your preferences to be honored. So part of a life plan should be the family's decision-making about their own end-of-life preferences. So we want to include that as part of the life plan for the loved one, especially if the loved one is not able to make decisions for themselves. So this exercise is called Planning Ahead, Favorite Things. What are the person's favorite way to spend his or her time? What does the person like to spend time? Who does the person like to spend time with? Very critically important. What places does the person like to go? And what are the person's hobbies? So these are some great basic questions that we want to be including in a life plan to make sure that, if there's a trauma that happens, the successors can know, first of all, know this information and make sure that these relationships stay in place. Mary sadly got dementia, and over time she did eventually pass away. Unfortunately, there's a tremendously high rate of this for people with Down syndrome. So Mary initially loved, one of her favorite activities was bowling. But over time she lost her capacity to bowl. But because it was in the life plan, and because in this case Barb was well aware of this, and she insisted that the group home, she eventually moved from a supervised apartment to a group home because she needed additional support. And but Mary's caregivers had a hard time. When she moved into the group home, she moved out of the supervised apartment because she needed more support than they were able to give. When she moved into the group home, though, she still spoke very clearly and well, and she still was able to do a lot of things. She loved to bowl. But as she lost capacity, the staff had a hard time really understanding how she's changed. So Barb staying on this with them helped remind them, rather than them saying, well, after a time, Mary's not able to bowl, Barb was able to say, well, still take her to the bowling alley, let her sit, let her watch, let her have a soda, make sure that you retain in some way the person's favorite activities, even if they're not able to participate fully in them. This next exercise is sort of the opposite and really important questions to ask. What are the things the person does not like? What are the things that they don't like or that annoy them? Are there people or the person around them that they don't want to be around? What makes them bored or grumpy? What's the person afraid of? Are there procedures that are necessary, but that the person doesn't like? So that you're addressing these things, addressing what you've done to help the person become comfortable with those procedures. I'll give you an example for Mary. And this was actually when she was still in the supervised apartment. So she, adjusted. She initially needed a lot of support from Barb, from her direct support professionals, of course. They had a staff apartment. These supervised apartments, as you probably know, have all different configurations for where staff are located. Are they on property? Are they not? Do they just come in and visit? And this apartment had a staff apartment. So there were a number of apartments in this complex where people with disabilities lived. Mary had her own apartment. She lived alone. She loved it. And there was a staff apartment. And Mary had a fear, and that was thunderstorms. And she loved to watch TV. She loved to watch the weather station. But when thunderstorms were predicted, she got really nervous. She got really scared and kind of, spent a lot of time talking about these things and actually charged up a whole bunch of money, calling the Weather Channel. At that point, you could call up and get the weather. So we had to address that. And one of the things that happened was she would go to the staff apartment very often. And the staff, surprise, they treated it like, no, Barry, go back to your apartment. Stop coming here. They were annoyed. And so and here's where we assisted in helping Barb advocate for Mary. We helped the staff to understand what was happening. And the fact was that she was not coming to annoy them. She was not coming, basically, she was coming because she was frightened and a thunderstorm was coming. And so what we were able to do was to basically work with the staff and put a plan in place, which included a number of things like a comfort box of her favorite items that she would go to and look at and enjoy to help calm her down and reduce her anxiety. But we also worked with the staff to say, oh, in fact, this is exactly what she does. She comes to the staff apartment because she needs comfort. She needs company. She needs them to reassure her and to say, at the first sign of thunder, we're going to be with you. We're going to come in and check on you. So helping the staff. So this is why a life plan has to really in detail talk about a person. What do they need? And also, how can we address these issues? So I want to also on our under tools on our website, under tools and resources, we've got this chart and this next chart. I'm going to talk about them briefly. These are also downloadable through where we got them from. It's called chartingthelifecourse.com. I'm sorry, lifecoursetools.com. Lifecoursetools.com. It's I don't know if you can read that here, but that's you can download these and many other tools. It's a wonderful format. It's for thinking about life planning, and this is another way to do kind of what we talked about just a few minutes ago. We want to put in a vision for a good life in that upper bubble. But we also, in the lower bubble, we want to talk about what the person doesn't want. So Mary had, after a while, she had difficulty swallowing and wound up choking on her food a lot and wound up needing a treatment called Thicket, where you put Thicket into liquids so that she could drink without choking. But she hated Thicket. And so we had to work on ways of her enjoying she loved soda, but we were able to actually introduce instead occasional milkshakes that were thick enough that she wouldn't choke on them and she could have a treat that she enjoyed. Because again, we, worked on soda was important to her, but we had to help her to understand her nutritional, the benefits. And so she only had soda, once in a while. So that helped to, reduce her requirement for thicket, but have a treat that she enjoyed. So these are wonderful tools. I recommend them. This one is called the Integrated Support Star. So down at the bottom, the green is the eligibility supports that we talked about, means tested benefits, DDD benefits, what's their budget, what's their tier, SSI, Medicaid, those kinds of things. We want to include that in our life plan. But up here, in the blue, personal strengths and assets. What are they good at? What do they like? What do they contribute? Mary had a great sense of humor and she loved to chat. She was fun to talk to. So this was an important asset that we wanted to keep in front of people so that they could understand her sense of humor, and that she was not always being obstinate because she was refusing to put a coat on. She was actually just teasing you. So we needed to, call attention to Mary's abilities and strengths. Technology is huge. iPads, iPhones have made a huge difference in people's lives. What else are of benefit to somebody, or have we, or would they benefit from, should we look into, have we thought about doing, haven't yet, but write them down so that resources that we have or resources that we want to get. Relationships in the purple and then community-based support, so important. If, Mary loved to go down the street to buy a slice of pizza from Frankie's Pizza, and that was really important. And she didn't want to go to Tony's Pizza. She wanted to go to Frankie's Pizza. These are important distinctions that we want to include in our planning for about telling the person's story to your successors. So how can Plan New Jersey help? We can serve as successor, backup for legal roles, financial roles. We serve as trustee for almost 600 active special needs trusts. And one of the reasons that people do use us as trustee is because they may not, the sibling might be terrific at making the medical decisions and the housing decisions and being the friend of the individual, but they might not want to deal with the hassle of reporting and accounting and taxation and distribution and knowing the rules that that won't cause somebody to lose their public benefits. So that's important and available should you like it. And sometimes just as successor. There might be 3 siblings that might be perfect as successor trustee, but what if they decide down the road they don't want to do it? Some families in their will add us as the 4th or 5th successor, or 2nd or 3rd. So it's a backup for families. Sibling guidance and family support is so important. I was talking to a woman who has agreed to be guardian for her uncle's 2 children. And she has a wonderful background. She's got special ed in her background, and really she's going to be able to, she'll do a wonderful job. Really caring, really lovely. But when I mentioned that Plan New Jersey provides home visit monitoring, that we can visit monthly and we can go there in case of an emergency, she really was excited because she's a professional. She's got 2 children, 6 and 10, I think, 6 and 8. And so it was very helpful for her to know, should something happen to her uncle, she could have some support and help. So we serve kind of as the eyes and the ears of guardians and trustees, especially if they live out of state. Life planning consultation, if after this meeting you'd like some help brainstorming about, which guardian might be, about guardianship, about if you've got some questions about how this might work, you are welcome to call our office, and we will get back to you as soon as we can. Just so you know, very often after these presentations, we get a lot of phone calls. So if you're calling just for guidance and information, we'll get back to you as soon as we can. And that's what we call a complimentary life plan consultation. You want some basic information. With the type of planning you're doing is very, first of all, individualized, but also dependent on the nature of the person's age. If they're a child, you've got many things to think about prior to adulthood. If they're an adult, if they're 20 versus 40, there's many different things, different ways of thinking about what their needs are and how you might go forward. We do provide this routine home visit monitoring and advocacy. Sometimes families will have us initiate this briefly for a year or so, or annually after we write a life plan with them and for them. So we write life plans with families. So sometimes if this is so overwhelming for you, you might want to ask us to consider writing, you might want to consider having us write a life plan and perhaps have those successor guardians, trustees, whatever the role, just family, participate in the life plan so they can hear you describe to us what the person is like and all about their supports and services that we then document for you. And it's the first step in informing and kind of securing your successors' buy-in to this process. And then, I do want to mention that our services can be just as needed. It doesn't have to be, typically families might ask us to write a life plan, but then we won't do anything. They're welcome to update the life plan as many times as they want, but we won't provide any other services. It could be for a decade, 2 decades, but sometimes it's not. They come in, there's a problem and there's some advocacy we need to do. DDD has said, they need some help with something. They want to change support coordinators and, or they want us to attend an ISP meeting for the individual. And sometimes it's short-term advocacy. So our staff, our primary staff are Jason Miller, Director of Social Services, Nancy Dillaplane, Director of Trust Services. If you are interested in contacting our office, I will refer you to Melanie McQuell, our Social Services Manager. But I will stop sharing now, and I see there are 20 questions. So good, we can have a conversation. And I'm going to ask Paul to, organize the questions and.
Okay. I want to give you a break, so let me just make a couple of points here. The issue came up about guardianship. I just want to repeat something that Joe Young, who's the retired former head of Disability Rights New Jersey, said about guardianship. He said the role of a guardian is to make decisions that the guardian believes the individual would make if the individual were capable of understanding the full ramifications of the situation. The guardian is not supposed to do what the guardian would want. The guardian is supposed to do what he or she honestly believes the individual would want to do. So that's a very important thing to remember. The reason for considering ABLE accounts in different states is that there may be different investment options in the different state plans, and you might be more comfortable with the options in one state versus another. Some states, not New Jersey, give a tax benefit for contributions to the state's own ABLE account. Since New Jersey does not, there is no inherent reason why you should use the New Jersey ABLE account option. You should look at, as Ellen indicated, you should look at other states and see which set of investment options is something that you're most comfortable with. I would say that it is absolutely essential that you prepare the successors You cannot just appoint somebody, have them agree, and then say that that's sufficient. We have come across far too many cases where parents, with the best of intentions, want to shelter a sibling from the stress and responsibilities as long as possible. That may be altruistic in intent, but it makes certain that the successor trustee or the successor caregiver or whatever the successor is responsible for will not be adequately prepared, knowledgeable, and ready to take over. So you really need to start preparing your successors to know what's involved, what the preferences of your child are, what the resources are, so that they can smoothly take over when necessary. And you have to make sure that your successor is not your sibling. Your successor has to be someone who is at least of the generation of your child. The younger the successor is, obviously, the longer they will be able to follow in that role, but make sure you're not choosing your own sibling. The child's aunt or uncle is not really an effective successor. It should be a sibling or a cousin or a close family friend, but someone who is at least the same generation as your child. So I think I've given you enough of a break, Ellen, and we can go to the questions. The first one I think is something that you discussed, but maybe you can elaborate a little bit more. How much input does a disabled person have for the future? I guess that's in doing all this planning. What should be the role of the individual?
That's a great question. It is essential that the individual be a full participant in the planning process. So what's unique about a life plan, as I've described it is a combination of the person's plan and the family's plan. So we know that with an ISP, with an individual support plan or other types of planning, those are typically about the individual, and they're more like a contract for services with DDD, with no regard to the input of family in particular, other than whatever they might, say at a meeting. But a life plan really does enable a family to indicate their wishes. However, we encourage the individual to participate, to express their wishes. We never write a life plan without meeting the individual. And it's sort of part of, I think that was a wonderful point you made about Joe Young's comment. A guardian, in addition to the self-determination concept, a guardian is required to make a decision as the person would want it. So a guardian should never say, this is my decision because I think that's what's best. A guardian has an obligation to provide informed decision-making to the individual. So my point is that always the person should be as fully involved as possible, using the type of communication tools they use, giving them as much time and participation as they may need to be fully involved. This is a plan with them and for them. So that's a great question. I'm really glad to highlight that point.
Yeah, that was. I mean, most of these questions, or all of them, are really very, very good questions, and should be given attention. This question came up. My daughter is 7 years younger than my son. Can she still be a guardian?
Yes, she can. A lot of, what I think that a court, I guess it depends on how old she is. That's really the question. If she is, in some cases, families, somebody who's 21 years old could be a guardian. And I know of a young person who was appointed to serve as guardian for his mother because his mother got into a terrible car accident. and had a traumatic brain injury. And so a lot of it just depends on the capacity of the individual. So one thing you could do is name one successor who you feel is older, with the intent for the younger person to become guardian as soon as they feel it, they feel that they can do it. So a lot of it, but like I said, I mean, judges could appoint, I don't think they would appoint somebody under 21, but they could do it.
There were a couple of questions on costs. One was how much is the cost, and another one had a number of issues. Who manages trust and the fees for trust? What is your administrative fee, referring to Plan New Jersey? Do you charge hourly for home visits? And the person noted that while in the hospital, what type of care is provided? Fee for service does not provide for a companion in the hospital. Is that something that can be done with a trust? And is that a service that can be provided by Plan New Jersey?
Okay, so we'll start with that last one, and the answer is yes, absolutely. We have very often served in that capacity. We are often the emergency contact. So we will go to the hospital, we will stay with the person to the extent that we might not stay and with them, but we can visit, we can, we will stay. We have spent, days with people. So, and I want to emphasize that is very often those kinds of supports. That really is the idea of a special needs trust, that you are paying to supplement, not replace, not to supplant, but to supplement what DDD won't pay for. So that would be a purpose of putting money aside in a trust, is to pay for things like that. So, and the answer is yes, Plan New Jersey will visit. In terms of costs, first of all, there are no costs until we are in that capacity. So our meetings to organize and arrange and become a successor trustee, there's no charge for any of that. We will meet with you, we will talk with you, we will set up, we need all sorts of documentation. We need your wills, we need your trust documents, we need lots of other documents, so that we could, if needed, if in the event that we are asked to serve, we've got everything we need. So there is no charge until we actually become trustee. And I will answer that question about those charges. There is no charge until we actually become guardian. So there is an hourly rate should we be asked to, say, do home visit monitoring. That's $115 an hour. So sometimes a family will want us to become future guardian, and they will want us to build a relationship with the individual. So maybe they'll want us to do monthly visits for 3 months or 6 months or quarterly or annually. So that's charged at $115 an hour. The only fee that is charged, we don't charge for consultations, for talking with us, getting ideas, getting information about how we would do it and what it would look like, and as I say, gathering all those documents. The one thing we do charge for is to write a life plan with you. So that is $900. That is a very comprehensive process. We're going to ask you to fill out a lengthy form. We're going to ask for all of your legal documents, all of your prior reports, your ISPs recently, some families have got, reams of documents. We will, work with you about what we need, but we're going to want all the historical information, or much of it, so that we have that history based on prior reports. So that's the only charge, is a life plan. Many families will update that life plan quarterly, annually. There's no charge for that. So we are a not-for-profit. We do everything we can to reduce fees or only charge fees for a specific service, and that is when we are monitoring, when we are serving as trustee, when we are serving as guardian. Guardianship is, again, it's charged hourly at $115 an hour. And the cost of that, and our fee schedule is on our website, so please feel free to go there and access it. And it's a little comprehensive because we want to be as clear as we can be. But so if somebody is in, let's say, a licensed group home and they are well cared for, or even wherever they're living, things are really in good, they have very good supports. The guardianship, again, it's charged annually. So it might be, $4,000 or $5,000 a year, because we are going to visit monthly. We are going to do that annual report to the court. We are going to attend every planning meeting. That is our obligation as guardian and our responsibility, because we do not just decide what's best for a person. We're not only deciding what the person wants, but we're also, as Joe Young says, we're also taking a look at what the family wanted and making decisions based on what's called a surrogate decision as opposed to a best interest decision. We want to know what would the family want for that person. Trusteeship, our fees are either, they're controlled by statute. There is a statute, it's on our fee schedule. Basically, it's $1,800 a year or the statutory rate, whichever is higher. That's a formula. I will say I was recently talking with two trustees from banks, two different banks, and one of them, one bank as special needs trust, their minimum fee is $5,000 a year, and another bank's trustee fee, minimum fee, that means no matter what, that's what you're charged, is $6,000 a year. So, gives you a sense of we're working very hard to keep our fees down. But as I mentioned, we are a stable, strong, not-for-profit, but we need to pay the rent and pay the salaries of the staff. Next question, Paul.
Okay, I would just reiterate what Ellen said. As someone who was in the financial services industry for my career, banks are looking for high net worth individuals. That's why they set the minimum fee so high. They don't want somebody coming in with $30,000. They want somebody coming in with $1 million or more, or at least $500,000. So that's why the minimum fee seems so high. They're trying to discourage some people. This question came up from a number of people in different formats, but I think you can answer this simply. If someone is a guardian, do they need to also consider having a power of attorney and a healthcare proxy?
No, the guardianship sort of trumps the power of attorney and healthcare proxy. In essence, it's a guardian. It's a life plan that should go with the guardianship and the trust to guide what you want to be done. But the guardianship gives a person, as long as it's guardian of the person and property, that is your legal authority to make decisions on behalf of the person. If it's, for example, guardian of the property only or guardian of the estate, then you would want a healthcare proxy to help to support that person to make housing or medical decisions, or vice versa. If it's a guardian of the property of the person, where healthcare and housing decisions are managed and overseen by a guardian, but there's no guardian of the estate, then you might want a power of attorney, a trustee, a representative payee, an ABLE account.
I would also add that to some extent, these are two different matters. A guardianship is for an individual who is judged to be incapable of acting in their own best interests. A power of attorney and a healthcare proxy must be given by someone who is capable of understanding the ramifications of granting someone else that authority. For example, my wife and I are guardians of our child. We each have powers of attorney and healthcare proxies for each other because we are both considered not needing a guardian. So we have to voluntarily and understand that we are doing this voluntarily, granting healthcare proxies and powers of attorney. So it's kind of either or based upon the situation. But I would add that you need to be careful. You cannot get a power of attorney from someone who is not capable of understanding what rights they're giving up when they give that to you.
Right, which is why I recommend that if you're thinking that your son or daughter would do just fine with a power of attorney and healthcare proxy, do go to an expert attorney so that you are, that person is helping with that decision about whether the person has the capacity to make that appointment. But let's say they did that and they had a power of attorney and healthcare proxy, but then later they lost capacity, or later it was determined that, you know what, they really need a guardian. In essence, those prior roles are just considered null and void because the guardianship would be.
Supersedes.
Mm-hmm. Right.
Okay, this one is for Ellen. How does Plan New Jersey work with support groups?
I'd love to have a little bit more specifics about that. We work with many support groups. We do a lot of presentations like this. Can the person be a little bit more specific? We try to collaborate. We do collaborate with many organizations and try to provide assistance or guidance in these areas where we might have a little bit more knowledge. We try to collaborate. Our advocacy is done in a soft advocacy approach. We're not trying to clobber people over the head. We're trying to help people understand the rules, the rights, the obligations, their rules, and and make sure that the individual is the person with the disabilities preferences are being honored and their needs are being met. I don't know if that answers your question.
If you can give more details, please submit another question and we can get to that later on. So please, if this was not a sufficient answer, just give some more details. Here's a question that has actually, I guess it's two questions. One, can you please address Plan New Jersey's limitations pertaining to providing support to individuals who are self-directing?
That is the question of the hour. It is a huge concern. I've actually had conversations with DDD about this, and we are forming a group of our board members to look at this question. I did learn that there is a brand new I believe it's called the Office for Education on Self-Directed Services with DDD. You can find it on their website. It's brand new. It's within like the first 60 days. So I wouldn't say that there's a tremendous amount developed as yet, but I think that I would recommend that everyone that is concerned with this question, as are we, it's a huge, important question, should, get in touch with that organization, speak with, I don't know, Paul, whether you could speak with about NJCDD's position on this, or so this is something that I think everyone that has anything in relation to self-directed services needs to look at. We've looked at support brokerage. That has to be better funded. It's got to be strengthened. We've got to get support brokerage organizations that are offering support brokerage, or people that are offering it, to be to really step up to the plate and make commitments as to how they are how they're going to plan to support families who are self-directed. So I wish I had more answers, but those are at least the things that we're looking at and very concerned about ourselves.
Let me try to address some of this. Everybody has a support coordinator. That person takes the place of the old case manager. The support coordinator is paid by DDD. A support coordinator is supposed to give you options, but not make decisions for you. So if you are looking for a residential placement or a day HAP program, they can give you the names of providers in your area, but they're not supposed to make the choice. A support broker is someone who is paid out of your budget, and that support broker can give you far more insight and help you make the decision as to what provider that you want. But the support broker, as well as the support coordinator, have to be registered with DDD. An organization like Plan New Jersey has more flexibility. They are not they're not answerable to DDD. They represent only you. They do not represent DDD, so they can perhaps give you more non-filtered advice, let's say. They are free to say whatever they honestly believes in your best interest. And I think if you look at the Board of Trustees of Plan New Jersey, you'll see that there are some very well-known family advocates on that. One of them, I saw his name previously. He's the president of the agency. He's on this call. Again, I think you can rely on Plan New Jersey to give you the advice that is in your and your child's best interest. There's a second question from the same individual. This is relating to the availability of Plan New Jersey services. Please clarify if Plan New Jersey is still accepting the role of guardian for individuals they don't currently serve, and if they will serve as co-guardian.
Okay, second question, second part of the question first. We do not serve as co-guardian. And we always prefer that if there is any family member available, that person serve, and we are available to support that person. So, and we can support that person in a very intensive way. Like we said, we can visit the individual, we can be an emergency response, we can go see them in the hospital, we can get the authority for to talk with doctors on the family's behalf. So we much prefer to support family to be guardian than to serve ourselves. However, so the answer is absolutely yes, we are accepting additional guardians. We have, well over 200 life plans in place, probably close to 300, and many of them are families that have named us as successor guardian, whether we're first, second, or third successor. Again, the more options you have of families and relatives and friends, that, that's ideal. But in some cases, families have said, you're it, you are who we want. We have been growing, our organization is growing and will continue to grow. Paul, I appreciate your talking about the Plan New Jersey board. It's a wonderful and committed group of people, family advocates, family of people with disabilities, a lot of skills. People with a lot of money skills, people with a lot of legal skills, people with a lot of medical skills. So it's a very active participatory group. And one of the things that we continuously work on is scaling our organization. So we had 70 trusts 10 years ago. Now we have almost 600 trusts. We had, so we are growing, and we will continue to grow and add staff and add, we very fortunately, just prior to the pandemic, probably tripled our office space, where it's the opposite of the way people are going from, but for us, we need the space to have, to add staff and expand to continue to serve the needs of New Jersey families.
And remember, you prepare for the future while you're capable. Plan New Jersey takes over if necessary, or to the degree necessary when you're no longer capable. So the planning phase is absolutely essential and must be done first. This is a question that I've heard numerous times. I'm very interested in hearing your response. Do I have to use my brother's trust throughout the year for his extras? I have been avoiding using it so he has some money if I predecease him, and I've been using my own money to support him for the extras.
Yes, that's a perfectly fine thing to do. Many families do that. So you can continue, you can save that money for his future. There's no requirement to spend it, as long as his needs are being met.
Just be careful, because if you pay for certain things for your brother, that can be considered income to him. Yes,
which is why you want to be very, So food, money, you never want to give the person money. If they're on any means tested benefits, that's considered income. That's part of the reason that you have to you have to look very carefully at whether or not you pay rent and other, gas and electric and utilities out of a special needs trust. You can do it, but you have to know the rules that might affect benefits. Certain Medicaid programs have different income requirements than others. So you want to be cautious. And that's the reason sometimes families will choose a professional trustee or, a trustee who's a CPA or an attorney or somebody that's really willing to get into the weeds of the law and the regulations so that you don't jeopardize.
And also try to, keep your eyes and ears open. There are knowledgeable attorneys who do free webinars where they explain some of the categories of expenditures that are eligible for a special needs trust and those that are not, and then what are eligible for an ABLE account and what are not. The answers are very, very specific, and you need to get the answer from someone who is very, very knowledgeable.
Yeah, there's a resource I'd like to share with you. The website is specialneedsalliance.org, and this is a group of specialist attorneys who specialize in people with disabilities. It's by invitation only, typically only 2 attorneys per state are included. And on the specialneedsalliance.org website under publications, they've got a publication called the Special Needs Trust Handbook. I believe that's the name of it, Special Needs Trust Handbook. They update it every year, and it's got the basics of special needs trust administration. So if you're asking a family to be the trustee, which most families are, include a copy of that handbook and suggest that they just get the updated one each year. And it's a great, just a, basic overview of the public benefits, the requirements, eligibility requirements. And so it's a great resource.
Okay. This is a very specific question. How can I become the rep payee for my daughter again? I signed her Social Security over to the group home agency about 3 years ago due to pressure. This is a question of somebody who apparently agreed to make the provider where her daughter lives the rep payee and now would like to reconsider that decision.
Okay, the Social Security Administration controls that decision. So you can make an appointment with the Social Security Administration. By the way, you might want to wait a little bit because they are so busy. We spend a lot of time with them that we're told they're not even making appointments right at the moment. Very tough, but soon because they just opened up their doors. But go to Social Security Administration and explain the situation and explain that you would like to be, you'd like them to change the rep payee to you, and they may do it.
Very clear answer. Here's another question. We have a first party trust. I presume that's a first party special needs trust. Where can I find out exactly what I can use the money for?
Probably that special needs trust handbook that I mentioned. You could also look at, some of these specialist attorneys' websites, like you mentioned. And many of those are listed on my website, on the Plan New Jersey website. So I would start with that handbook. And basically, there are many things you can use. It's not like it's not like you can't use many things. It's really to supplement versus supplant. I would read the document carefully. The trust document is what guides what you can do. There are certain things specifically you can't do, like giving the person cash, you can't pay for food because that's supposed to come out of their Social Security benefits. And for New Jersey, you want to be very careful if you're buying anything over $5,000. You must notify Medicaid. That's a particular rule, particular to New Jersey. but it is important to use the funds for the person's benefit. So I would do that. And, you know, the other thing to do, remember, I am not an attorney. I'm not giving you legal advice. So, you know, you can spend some money out of that trust to get some guidance as to how to use the trust. That's probably your best way to go, is sit down with an attorney to give you that guidance about what you can and can't do.
I want to go back to a prior question. While I can't give you a definitive answer, the question came up about an individual in hospital and the inability to use the budget, the Medicaid budget. I know this is under consideration by DDD. I'm a member of something called the Family Advisory Council. We have one representative from each of our 10 regional family support planning councils, and I think 3 or 4 or 5 people who were appointed by DDD. And we have been discussing this subject intensively with the director of DDD, the Assistant Commissioner Jonathan Seafried. He's aware of the fact, as we keep pointing out, that hospitals have limited capability to provide the services that individuals with IDD may have. The Medicaid rule generally is you can't charge for 2 services simultaneously. So if they're paying for the hospital, they don't pay for DD services. But we're pressing very hard for an exception when an individual with developmental disabilities is in the hospital, and this may very well be an individual who can't communicate directly. There's an overwhelming need for someone who is more familiar with the individual to basically communicate with the individual and the hospital staff. So hopefully there'll be a change here, but at this point, all I can say is it's under intensive discussion, but no decision has been made. Okay, here's another specific question. Can an agency charge any amount for contribution to care? The rent is 30% of income, but the contribution to care is more than my young adult's total Social Security after rent. Let me just add here that Medicaid funds cannot be used for room and board. So a residential agency will charge separately for those things, but they are supposed to, indicate that they are using that money for valid expenses that are not generally included in rent, but they would include food. But this is again an issue that comes up. My understanding is that the agency can't charge the individual more than the individual's income. If you have anything to add, I'd appreciate it, Ellen.
Yeah, no, I don't really have anything to add. I think I would not be shy about speaking with the agency about what exactly they're looking for, break out the budget, what are they charging, and why. And if you have a concern, maybe call the DDANJ, or rather the what's the name of the law?
Disability Rights New Jersey.
Disability Rights New Jersey. There it is. Thank you. You might call Disability Rights New Jersey and talk with them about whether or not this is fair and appropriate to be charged.
I mean, I know the individual who submitted this question, and I would be happy to speak with you offline on this subject. It is an issue that affects a great number of individuals and has to be dealt with. This is kind of a general question that has come up on the differences between the 3 types of trusts: the first party special needs trust, the third party special needs trust, and the ABLE account. In terms of the rules for paying back to Medicaid upon death. If you could just, repeat that in terms of the 3 specific types of accounts.
So basically, the first party special needs trust and the ABLE account are payable back to Medicaid. And the third party special needs trust or supplemental benefits trust, a couple different titles for them, that is not payable back to Medicaid. So you're attending this webinar, you realize that you really want to make sure that your planning is in place, and that so what you want to do now is make an appointment with an expert attorney, or if you don't think you have a lot of money, call our office and ask about our pooled special needs trust, which does not cost any money to sign up for. You can simply sign a joinder agreement and have it available to you. If you can't, if you don't want to spend the money to speak to a lawyer, well, you can at least know that you've got a third-party special needs waiting for you. It was written by an expert attorney, Herb Hinkle, and amended by an expert attorney, Tom Begley. And so that's available at no charge. So, but otherwise, make your plan with your lawyer, and then that money, your money, will go into a special needs trust, a third-party special needs trust. The only time you would have money go into a first-party special needs trust, regardless of your planning, is if the money, let's say a lovely, kind grandma left money in her will for your son, that money has to go into a first-party trust because it was left directly to him. It's owned by him.
Yeah, I would add that if you have family members who are planning on leaving money to your child with developmental disabilities, you really should ask them to make sure that it goes into a special needs trust, a third-party special needs trust, and is not given directly to your child. If it goes into a third-party special needs trust, then there's really no problem. The assets never belong to your child. And the reason for the differences among these three accounts is a first-party special needs trust contains money that originally belonged to the individual. So Medicaid has provided service to an individual who had money, so they want the money back to cover the cost of the services. The way an ABLE account works is, again, the money belongs to the individual. Whether the person funds the ABLE account himself or herself, or a family member funds it, once the money goes into the ABLE account, it belongs to the individual. There's no trustee. It's the individual's personal account. If you are a guardian of the property, you can control it, but the assets belong to your child, not to you. So again, Medicaid has the right to recoup whatever it spent on your child. The third-party special needs trust, the money never belonged to your child. So Medicaid has no legal attachment to that money. Okay, here's a question. I heard this a couple of times. My son has an IRA account, which is over $60,000. Once he reaches the age where he can take money out of the IRA, can that money go into a first-party trust?
I'm really going to recommend you to an attorney for this. It's a complicated topic. But if it's an IRA that is in his name, that right now is an asset of his. So take it out or not, it belongs to him. So you would really want to seek out expert legal advice as to how to manage that.
And there's also the potential to put that money into an ABLE account. But again, you should seek competent financial and legal advice. Okay, here's a question asking for correction. Please correct for listeners that a special needs trust cannot pay rent, cannot pay for shelter or food.
That's right.
Yeah, if that money is used for that, it's considered income to the individual and can disqualify them from Medicaid. Okay, here's a question for Plan New Jersey. Do you work with ISPs, individual service plans?
Well, if you're asking whether or not we are funded, we are an approved vendor, we are not. We want to stay independent, as Paul mentioned. So we want to be able to advocate on your behalf. So the only way we work with an ISP is to help a family monitor it, help a person monitor it. We will attend ISP meetings to help make sure that your preferences or the individual's preferences are honored and included. If there is a concern or a problem with a direct service provider, we will help advocate. to make sure it gets implemented. So that's, and then we include the ISP in a life plan so that we've got all the possible information. But we are not a vendor of services,
Kyoko, did you want to comment on this one?
Hi, Paul. Which one?
Do you work with ISPs?
I think Ellen answered the question.
Okay, fine. Could you please review the differences in third-party and first-party trusts and the ABLE account? I think we did in terms of the where the money comes from and what happens upon the passing of the individual beneficiary. I would also say that there are subtle differences in what an ABLE account can be used for compared to a special needs trust. Again, you might want to consult with your attorney because you want to make sure that you don't take money out of any of these for expenses that are not allowable and might jeopardize your child's eligibility for Medicaid. So be very, very careful. Here's a simple one for you. Is there an organization like Plan New Jersey available in Pennsylvania?
Yes, there is. Yep, there is the Plan of Pennsylvania. And then there's another one that's more out in Pittsburgh area. So if you go to the National Plan Alliance, all one word spelled out, there are a number of states that are identified as members, and Plan of Pennsylvania is listed as a member.
Please explain again, are you saying that if you have a trust fund for your child, the bank will charge you an annual fee? If you have any kind of trust, the trustee, whether it's an individual or an institution such as a bank, they will charge you a fee. There's going to be a management fee, and most likely it's going to be an annual fee based upon the size of the assets in the trust, but there typically is a minimum charge. Again, every trustee wants to avoid having a lot of small trusts, which I suspect is the reason that Plan New Jersey tries to accommodate people with smaller trusts by managing a pool trust, where you can get the trust services from Plan New Jersey at much lower cost than the minimum cost that a financial institution would charge you.
Right.
I think that's accurate, Ellen. I thought it would be better if I answered that one than you did.
Sure. Yes.
Since I prefer to recommend you rather than have you recommend yourself.
I appreciate that. Thank you.
But that is the essential reason why Plan New Jersey has a pool trust. It spreads the cost over multiple people so that each trust, each person is charged less. I don't know that you can answer this. Are there any programs that help people with disabilities get a job? Because the previous two programs that my son went didn't really help him. With the current internship program was the only one that got him a job. That's a very complex question. We have been at NJCDD, we have been working on this, trying to create programs that pilot programs that give people the opportunity to have internships, because all the evidence suggests that people who have internships have a much greater chance of having competitive employment. And the earlier you get exposed to jobs and job skills and internships, the more likely you are to be successful. This is something that you might want to bring this up at your local regional family support planning council or a statewide family support planning council meeting. There's one in 2 weeks, 2 weeks from today on May 14th, because there are advocacy groups that are working on this. And we also have another group. We have formed something called the Developmental Disabilities Advocacy Network. And one of the work groups, and I should say both Ellen and I are participants in the Developmental Disabilities Advocacy Network. But one of the work groups, neither of us is on this specific work group, is working very actively on the issue of competitive employment for people with developmental disabilities. So you might want to check or contact the staff of NJCDD for some leads that might help you become better acquainted with what is available in terms of assistance with seeking jobs for individuals with IDD. Next question. I am part of a group that is building an intentional planned community for our kids with IDD and typical people. It is consumer controlled, not provider controlled. This is novel to New Jersey. We need help understanding how our kids' budgets can be used to pay for 24/7 DSP services. Support coordination agencies are not familiar with this model, and I don't believe they know how to address this. Can Plan New Jersey help us out?
At this point, this is another area that needs a tremendous amount of work. And I believe that there are 1 or 2 attorneys in the state that are working to guide families. There are a couple of organizations that are working to guide families. This is a very important question. And I'm not sure that Plan New Jersey is ready to provide you with that kind of information. I think that I would seek out, I might go to the Supportive Housing Association of New Jersey, SHANJ.org. I think that this is where they may have more resources and expertise to develop.
I would certainly agree with that. I know I was involved in founding a family work group under the aegis of SHAW, the Supportive Housing Association. And, we had done some work on this. So yeah, I would definitely contact SHAW of New Jersey on this. And I know we worked with a couple of attorneys who gave us some pro bono advice on, how to go about doing this. And I know at least one other group that is working on this. This is very, very complex, and you really need expert advice. Okay, let's see. If your child uses Plan New Jersey and at some point moves to New York to be with family, would Plan New Jersey help the New York Guardians set up supports in New York?
We would help with the transition in any way possible. The New York Guardians are going to be the ones that are familiar with the supports and resources and services in New York, but we would absolutely assist and facilitate and provide any information that we can to make the transition.
This is a very complicated one. Can I use my son's money for renovations to a bathroom in, quote, our home, unquote, even if I do not charge him rent?
It is a very complicated one, and I'm going to refer you to an attorney as to how you might do that. I do recommend that you charge your son rent. That's what any kind of social security funding is for. And I recommend that you do that. Keep the money in a separate account. Feel free to, afterward, definitely don't commingle your funds, his social security funds with yours, but charge that rent to avoid a rent reduction. And in terms of that, I would say go to an attorney to talk about how you can do that.
Also, if your child is receiving SSI supplemental security income, your child is entitled to a higher rate if your child is paying rent. If your child is not paying rent to you, the state will assume that the family is providing that and your child needs less income. So again, this is something where you need good legal advice. If your child is getting SSDI or supplemental security disability income, that's different. But SSI is a lower amount, and there are 2 levels in New Jersey. One which assumes that the family is providing room and board, and the second assumes that the individual is paying for their room and board. So I would strongly advise you to look into both of those. Here's a question, and again, this comes up very, very frequently. Can you use first-party special needs trust to fund an Enable account?
Yes.
One of the attorneys that we had consulted for Shaw strongly recommended that you do that because there's a little more flexibility in what you can use the ABLE account for. It's not quite as restrictive as the special needs trust. So his advice was you should certainly consider doing that.
Correct. So we sometimes will use money from a first or third party special needs trust to pay into an ABLE account to pay for the use of paying for the purpose of paying rent. And then you don't have that reduction that Paul referred to. Because
yeah, I'm not sure exactly what it is, but it was over $200 years ago when my son received SSI.
right.
That supplement was provided by the state for individuals who needed help with room and board.
Correct. Yep.
But you have to be aware of that, and you have to prove that your child is actually paying for room and board to get that money.
Yes.
So you need to have an agreement, and you need to keep records.
Yes, that's right. Document, keep careful records with all of this. Very, very important.
Here's another question. How can an individual with IDD pay for assisted living and still keep their Medicaid eligibility for DDD services?
Well, if you're talking about assisted living, say in a that's if you're talking about paying privately for assisted living, I guess that's too complicated to provide a short answer. I think I would suggest get legal advice on that one.
Yeah, I haven't seen this question before, and I really have not heard anybody address this. So I would give the same advice. You need to consult an attorney if and how that can be done. My son wants people with disabilities. To find programs in New Jersey that can give them jobs, because some of the ones he went to didn't help him for 5 years. The internship, I think this is a restatement of a previous question. I would ask you to contact NJCDD. You can call next week and ask for someone who can give you some advice on what information is available. I think this last one may pertain just to Plan New Jersey. It's how much of a minimum fee. I think you explained what your fees are, so I'm not really sure what the questioner means by minimum fee.
Yeah, so if you go on our website, our fee schedule is on that website. It's very specific, and feel free to just give us a call and we can talk about your specific question and see whether we can clarify.
The last one is a comment. It's addressed to you, which is thank you. And, I want to add my thanks to you, Ellen, for your time, your knowledge, your consideration, your kindness to all of us. And I'd just like to close by again saying what's really important is not just that you listened and participated, but that you have a plan going forward. And I realize that there was a lot of information given today by Ellen, and it's a lot to absorb, but you really do need to take action before it becomes an emergency. I'd just like to tell you that and this has happened to a number of parents that I'm aware of, where a parent passed away unexpectedly and a child was taken out of the home because DDD had to place the child that day. So DDD will take your child and place your child wherever in the state of New Jersey there is a bed that night. It may not be where you wanted the person to go, your child to live. It may not be where your child wants to live, but just think of it, at the very least, all at once, your child loses her home, her parent, her friends, her day program. This would be overwhelming for you and me, let alone a child with developmental disabilities. So this just, is further evidence that planning for your child's future is absolutely essential. The other point I want to make is that you're not alone. There are resources, you have family, you have friends. there are community resources, there are organizations like Plan New Jersey. There is help available to assist you in doing the planning, but you have to take the first step. You have to decide that this is something that I have to do. And then you can gather up your resources and find out who is available to help you. So again, I just want to thank all of you for taking your time to learn about this absolutely essential need for you to take care of your child. And again, my utmost thanks and respect and admiration for Ellen Nalven for all that she does to help our families with the succession planning and implementation process. So thank you so much, Ellen. I don't know if you want to add anything before we close.
Yeah, thank you. And I really appreciate all your wonderful questions and your attention to this very complex question. But, you know, I've tried to give you a few illustrations of how different families have approached these topics. But as Paul had said, this is a challenging and frightening situation. And what we want is to have the person have what they want, have the life that they want, and we want to stay in control as much as possible. So, you know, another reason to plan is, number one, to talk about, you know, your preferences as we talked about housing, and, you know, an alternative, if you have to the scenario that Paul mentioned, where DDD will just take them and place them wherever. Where families have been able to provide resources in a special needs trust, we've been able to, instead of that, we've been able to, the same day, hire a live-in caregiver temporarily while we advocated with DDD and said, for these reasons, we're not just going to plunk this person anywhere. We want to review and have some choice about where the person might move to, what might happen with their home, and how they might continue to have as much stability and maintain the similar schedule that they had before. And so we've had success in this. We've done this many times, where we've been fortunate enough to have some resources to use for the person, so that we then can take a little bit of time and not just move the person, but keep them safe and secure, keep them in their routine, and use those resources to, in this case, fund a live-in caregiver until we could, you know, manage the sale of the home and do all of those things. So plan ahead, do this. Paul, I appreciate your, you know, your leadership in this, because it is such an important topic. And as I say, feel free to call our office, brainstorm with us. We appreciate all your attention. Thank you.
And these were really wonderful questions. This was a terrific audience. Just one last caution. I have been aware of two families that had the ultimate tragedy, where an aging parent was living with a middle-aged individual child with developmental disabilities, where the parent passed away and nobody was aware of it. In one case, where an agency where I'm on the board of trustees was providing some case management, it took 3 days before a neighbor in an apartment building noticed that she hadn't seen the mother or her son. She called the superintendent of the building, the super. He opened the door. The mother had passed away in bed at night, and the son had been alone for 3 days. He didn't know what to do. He didn't know how to call anybody on the telephone. He was just sitting on the sofa. And I just learned of another one this week where a similar thing happened, but because it wasn't an apartment building, it took 2 weeks before somebody became aware that there was something wrong, and they found a live daughter in the home with a deceased mother. So I don't want to scare you unnecessarily, but it is absolutely essential that you provide this final service to your child, to make sure that your child lives a long, safe, healthy, happy, and productive life. So you've taken the first step here. The next step is to plan how you're going to make and prepare a plan for your child's future. So please do it. And again, consult with Shaw, New Jersey. You can consult with the Bog Center. The Bog Center is another federally mandated and supported group. Every state has a university center for excellence in developmental disabilities. Bog Center, BOGGSCENTR.org. They run a lot of training sessions for families. They have a DD lecture series where they bring in out-of-state experts to discuss issues of great interest to us. And I have to say that, you know, your child with developmental disabilities does not come with an instruction book. The only way you find out how to take care of your child is to talk to other people, listen to experts, and exchange ideas. Build up your Rolodex, because I can assure you that any challenge you and your child face, you're not the first ones. Somebody else has encountered that challenge previously. And if you know enough people, you'll either find someone who has encountered that challenge and either dealt with it successfully or found out ways not to deal with it, or they'll be able to tell you about somebody who has. I often tell people, you can ask me any question. Most of the times I don't have an answer, but most of the times I know somebody who can help you. So, you know, talk to other families with developmental disabilities. Go to the Bog Center, go to Disability Rights New Jersey for some legal guidance. Go to your Regional Family Support Planning Council and look at the website of njcdd.org. These are all resources that are readily available to you with people who are there to provide you with information, guidance, and assistance. So again, thank you all, and especially to Ellen, and hope to see you all at our next family forum. We haven't decided on the subject yet, but we will keep doing these, and the other regional family support planning councils are doing them also. One of the wonders of doing these things virtually is that you can go to a webinar run by any of the councils. You don't have to travel from Warren County down to Camden County. You can just go to your computer and catch it live. So thank you all. If you want to see a repeat of this, it will be available on njcdd.org, as will the slides. So thank you, and enjoy the rest of the weekend. And again, thank you, Ellen.
You're welcome. Bye, everyone.
And thank you, Kyoko.
Yes.